Stop whatever you are doing right now, because if you or anyone in your family has a green card application pending, or if you are planning to file one, what I am about to share with you in the next 12 minutes could be the most important immigration information you receive this entire year. USCIS has quietly implemented a set of overlapping policy changes that, together, are causing nearly 45% of green card applications to be flagged, delayed, or outright rejected. And the most dangerous part? Most applicants have no idea any of this is happening. They filed their paperwork in good faith. They followed the old rules. And now those old rules no longer apply. This is not a rumor. This is not political commentary. This is a fact-based policy breakdown. And we are going to go through every single piece of it, step by step. My name is Raymond Crivello. I am a senior immigration analyst and consultant. And on this channel, I break down complex immigration developments into clear, fact-based analysis that you can actually understand and act on. I do not traffic in fear. I do not deal in rumors. I deal in policy memos, federal registers, regulatory changes, and legal precedent. And I translate all of that into language that real people can use. Before we go further, I want to be transparent with you. I am not your attorney. Nothing in this video constitutes legal advice for your individual situation. This content is strictly for educational and informational purposes. Please consult with a licensed immigration attorney about the specifics of your case. That disclaimer matters, and any channel that does not give it to you is not one you should trust. Now, let us talk about what is actually happening. To understand why rejection rates have climbed this sharply, you have to understand that this is not one single policy change. It is three separate but converging shifts happening simultaneously in the first quarter of 2026. And when they hit together, they hit hard. The first, and arguably the most significant, is a USCIS Policy Memorandum issued on January 1, 2026. This is a real, official document, Policy Memorandum PM-602-0194, and it is currently available on the USCIS Policy Memoranda page. I strongly encourage you to look it up directly. Here is what that memo does. USCIS has placed what is called an adjudicative hold on all benefit applications. That includes I-485 green card applications, I-589 asylum petitions, and several other benefit categories, filed by individuals from a designated list of 39 countries classified internally as high risk. Now, the memo does not use that term publicly in those exact words, but the operational effect is identical. Applications from these countries are not being processed on a normal timeline. They are being held. They are being reviewed under an enhanced scrutiny standard, and officers have been given expanded discretion to issue requests for evidence or denials based on what USCIS is calling adjudicative risk factors. But here is where this becomes critical. The memo does not only apply to new applications, it explicitly states that previously approved cases may be subject to re-review. Let me say that again. If your case was already approved under previous standards, it could now be reopened and re-examined. And if officers find any inconsistency, even a minor one, in your prior submissions, your application can be denied. That is not speculation. That language is in the memo. Now, I want to be fair and analytical here, because that is what this channel is about. USCIS does have the legal authority under the Immigration and Nationality Act, specifically INA Section 103, to issue administrative guidance that reshapes adjudication standards. This is within their regulatory authority. What makes this moment unusual is not that they are exercising that authority, but the breadth and the timing of how they are doing it. If you are from one of those 39 countries, or if your spouse, parent, or child is, your application is now in a fundamentally different processing environment than it was 6 months ago. This is not about guilt. This is about administrative classification, and it has real consequences for real families. Let me give you a picture of what that looks like in practice. Imagine a family. Let us call them the Ahmeds. They immigrated from a country on that list 7 years ago. The father is on an H-1B visa. His I-485 adjustment of status petition was filed 2 years ago. He has been patient. He has followed every rule. He has never had a violation, never missed a filing deadline, never worked outside the scope of his authorization. His priority date became current in January 2026. He and his family were ready. They had gathered every document. They were expecting an interview notice. Instead, they received a request for evidence, an RFE, citing adjudicative concerns related to country of origin documentation standards. No specific error was identified. Just a blanket hold applied because of where he was born. His wife and 2 children, who are derivative beneficiaries on his petition, are now in a state of complete uncertainty. The children are in high school. The family has built a life here, and they are waiting, not because of anything they did wrong, but because of a policy shift they had no warning about. This is not a dramatic story. This is a composite of real situations playing out across the country right now. Now let us talk about the second major shift, and this one affects a much broader population. Even people who are not from those 39 countries need to pay close attention here. The Biden administration's 2022 public charge rule was considered a significant expansion of who could qualify for a green card. It narrowed the definition of what government benefits would be counted against an applicant. It gave adjudicators less discretion to deny based on past benefit use. For many low-income families, it was the policy that made a green card feel possible. That rule is now being rescinded. DHS proposed this rescission in late November 2025, and by February and March of 2026, the regulatory process has moved into its final stages. Under the new standard, which mirrors and in some ways exceeds the pre-Biden framework, any applicant who has received what are called means-tested federal benefits may face a finding of inadmissibility under INA Section 212A(4). Means-tested benefits include supplemental nutrition assistance, what most people call food stamps. They include Medicaid in certain forms. They include supplemental security income. They include federal housing assistance. This is what many green card applicants are fundamentally misunderstanding right now. Receiving these benefits during a period of economic hardship, something many families did during the pandemic years, could now be used as grounds to deny your I-485. The USCIS officer reviewing your case has been given expanded discretion to weigh the totality of your circumstances, and benefit history is now explicitly part of that analysis. Data from organizations like the National Immigration Law Center, NILC, suggests that this tightening of the public charge standard is directly contributing to inadmissibility findings rising from the previous baseline of around 20% to the current range approaching 45% when combined with the other factors we are discussing. If you have received any federal means-tested benefits in the past 3 to 5 years, you need to speak with an immigration attorney before filing or continuing your I-485 process, not after you file, before. The timing here matters enormously. Now, some of you watching this are already in process. Your application is already pending. What does this rescission mean for you? That is where the administrative procedure becomes important. Generally speaking, regulations apply to cases adjudicated after the rule's effective date. But given that officers now have expanded discretion in weighing totality of circumstances, the practical impact on pending cases is real, even if the technical legal applicability is contested. Courts may ultimately weigh in on this, and that is something to watch closely in the coming months. Now we come to the third piece, and I want you to pay very close attention here because the timing is not a coincidence. April 15th, Tax Day in the United States. USCIS has issued new internal guidance to adjudication officers, effective 2026, that specifically targets tax compliance as a component of good moral character determinations. Good moral character is a legal standard required for naturalization under the N-400, but it also appears as a consideration in I-485 adjustment of status reviews. Here is the specific issue. If you are a lawful permanent resident or a long-term visa holder filing for adjustment, and you have foreign bank accounts, foreign financial assets, or foreign income, you are legally required to report these to the IRS. The mechanism for reporting foreign bank accounts is called the FBAR, the Foreign Bank Account Report, filed separately from your tax return. The threshold is any foreign account that held over $10,000 at any point during the calendar year. USCIS officers in 2026 have been directed to request tax transcripts and cross-reference them against financial disclosures. If there is a mismatch, if you had foreign assets that were not reported, or if you failed to file an FBAR, that is now being characterized as a lack of good moral character. And a finding of lack of good moral character can deny your green card or your naturalization application outright. The civil penalty for non-willful FBAR violations currently sits at over $16,000 per violation per year. But beyond the financial penalty, the immigration consequence is what concerns us here. USCIS is using tax non-compliance as a direct grounds for denial, and the April tax season timing means that officers are actively pulling and reviewing transcripts right now. There is one detail most people are completely missing. Having foreign income or foreign bank accounts is not itself disqualifying. Many immigrants legitimately have financial ties abroad. What is disqualifying, under the new guidance, is the failure to disclose those assets in accordance with IRS requirements. The act of non-disclosure is what triggers the character concern. So if you have foreign accounts and you have been filing correctly, you are likely fine. But if you have not been filing correctly, or if you are unsure, this is the moment to get ahead of it. Now I want to give you a concrete action plan, because information without direction is anxiety, and that is not what this channel is about. Step 1. Audit your benefit history. Sit down and make a complete list of any federal or state benefits your household has received in the past 5 years. This includes SNAP, Medicaid in any form, housing assistance, and SSI. Then discuss that history with a qualified immigration attorney before your next filing action. Do not assume it will not matter. Under the current standard, it very well might. Step 2. Get your tax compliance in order. If you have foreign bank accounts or foreign financial assets, contact a tax professional who is familiar with FBAR requirements immediately. The April deadline is approaching. If you have missed prior filings, there are IRS voluntary disclosure programs that may reduce your exposure. Getting into compliance before USCIS reviews your transcript is far better than trying to explain a discrepancy after the fact. Step 3. Check your country of origin status under the new adjudicative framework. If you or your petitioner is from one of the 39 countries subject to the adjudicative hold under PM-602-0194, work with your attorney to understand what additional documentation may be required and what the realistic processing timeline now looks like for your case. Step 4. Do not file prematurely. I know the instinct when a priority date becomes current is to file immediately. But in this environment, filing before you have addressed public charge concerns, tax compliance gaps, or documentation weaknesses could result in a denial that then becomes part of your permanent record. A short delay to prepare correctly is almost always better than a fast filing that results in a denial. Step 5. Be cautious of any consultant, notario, or online service that claims they can resolve these issues quickly or guarantee a particular outcome. The complexity of the current environment is being exploited by bad actors who are targeting the immigrant community with false promises. If someone is guaranteeing you a green card approval for cash, walk away. Only licensed immigration attorneys can give you legal advice, and even they cannot guarantee outcomes. Let me step back for a moment and give you the broader picture, because I think it is important to understand where all of this is heading. What we are witnessing in early 2026 is a comprehensive administrative tightening of the legal immigration system. This is not happening through Congress. No new immigration legislation has passed. This is happening through executive and regulatory action, through policy memos, through regulatory rescissions, through internal guidance to officers. That means it can move quickly, and it can also be challenged quickly. Legal organizations including the National Immigration Law Center and the American Immigration Lawyers Association have already signaled that litigation is likely on multiple fronts, particularly the public charge rescission, which raises significant questions under the Administrative Procedure Act about whether proper notice and comment rulemaking was followed. If courts issue injunctions, some of these policies could be paused, but that process takes months, sometimes years, and in the meantime, real applications are being denied today. This could affect you even if you are not currently in one of the directly impacted categories. If your spouse is filing an I-485 and you are a U.S. citizen petitioner, changes to admissibility grounds still affect your family's outcome. If you are an employer sponsoring a foreign national worker for a green card, the adjudicative delays and new scrutiny standards affect your workforce planning. If you are a green card holder considering naturalization, the expanded good moral character analysis under tax compliance guidance is directly relevant to your N-400 timeline. The immigration system is interconnected. A shift in one area sends ripples through everything else. And the pace of change in 2026 means that the guidance your attorney gave you 18 months ago may no longer reflect current adjudicative reality. I want to close with something I say on this channel often, because I believe it deeply. Immigration status is not just a legal category. It is the foundation on which families build their lives. It determines whether a parent can attend their child's graduation without fear. It determines whether a skilled professional can accept a job offer, start a business, or sign a mortgage. It determines whether the years someone has invested in becoming part of this country will be honored or interrupted. That is why accuracy matters. That is why policy literacy matters. When the rules change, and they are changing right now, the people who are informed are the people who can respond, and the people who are caught off guard are the ones who suffer consequences they did not see coming. You are watching this because you care about getting it right, and that is exactly the right instinct. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential. If this video gave you clarity, please give it a like. It helps this kind of factual, responsible content reach more people who need it. Drop your visa category in the comments below. I read them, and it helps me understand what topics matter most to this community. And if you know someone with a pending green card application, share this video with them today. Not tomorrow. Today. Because the timeline on some of these changes is moving faster than most people realize. I will see you in the next update.